Hello, everyone, and welcome to our webinar for today from Ohio Recovery Housing. My name is Danielle Gray, and I serve as the Executive Director for Ohio Recovery Housing, and this is our next session in the Recovery Housing Institute. This session is a big one because we're going to talk about one of the most important documents that you will have with your residents, the resident agreement. We will also be talking about paid work agreements as well as other considerations for staff and volunteers at your recovery home today. So we'd like to have this webinar after our session on landlord-tenant law. And so I hope you had attended that session that we had a couple weeks ago, because this is where we put into practice much of what you learned from the attorney that spoke with you on that session a couple weeks ago. But of course, even if you had missed that session, it's okay. We can still get a lot out of today's session. We just encourage you to look out for the next time we have a session on landlord-tenant law. And so our objectives for today are first to describe the resident agreements and how they can be used to support a positive recovery environment within your recovery home. Next, we are going to identify strategies for developing resident agreements that include key elements to meet national quality standards. And finally, we are going to describe paid work agreements, what they are, and how your organization can develop a policy regarding such agreements or arrangements. And so let's start off with a bit of virtual discussion. And so hopefully you have all located the question box. And into there, I just want you to type in an answer to this question. How does having a resident agreement help you as a recovery housing operator? So go ahead and take a minute and think of an answer to that question and type it into the question box. Okay, I've got some responses here. So it outlines the agreements between the landlord and tenant. Somebody else says protects both parties. That's true too. It protects both you and the resident legally. And to make things crystal clear. That's true. A good resident agreement makes things very clear. It reduces confusion, reduces the likelihood that you have difficult conversations in the future. When residents question anything, you have a document that you can rely on that they signed. Yep, so that is true as well. And you can remind residents of what they signed. And then somebody else said helping residents understand guidelines and expectations as well as what they can expect from you. That's true. Yep. So it's a two-way street. So they understand their expectations, but they also know exactly what they can expect from you. And other people mentioning expectations as well, setting appropriate expectations, and a lot of people saying that. So those are all really great. So and it makes things clear, and it reduces misunderstandings. Yep. So those are all really great answers. A really well-written resident agreement is all about setting good expectations, reducing any misunderstandings you might have, and really just, again, establishing that good relationship between you and the resident. And so as you can see, in addition to protecting you and the resident legally, there are other really good reasons to have a well-written resident agreement for promoting a recovery environment. It really does help implement the social model of recovery because residents are empowered to understand their rights and responsibilities. So it's not just about what's expected of them, but also what they can expect of you, and they're empowered to know that and to act accordingly. It also ensures a shared understanding of the environment and helps everyone take the agreement seriously. The resident agreement is a legal document between you and the resident, and therefore it is important that it be treated with care. And so we highly encourage you to seek legal guidance about this document from someone who is familiar with Ohio landlord-tenant law. And today, I hope that you become better at issue spotting and identifying potential problems, as well as developing skills you might need to draft certain language with your resident agreement that can be reviewed by your legal counsel. So these can help you have really intelligent conversations with your legal counsel and keep discussions brief and make sure you get the most out of your conversation. So while we cannot replace legal guidance here today, that's not the purpose and intention of what we're trying to do. We hope that this session can help save you some time and therefore money when you go and talk to your legal counsel. And also today we'll be discussing best practices as well as NARR standards. And so a couple weeks ago, when you took the training from Joe Moscoviak, who is an attorney in Ohio landlord tenant law, he was really talking about basic legal requirements. And you are always required to follow the law. That is, there's no way around following the law, but there are also best practices and quality standards that create positive recovery environments that are not legally required, but are required under the NARR standards for homes that are seeking recognized as high quality recovery residences. So for example, a couple weeks ago, you learned that it is legally acceptable to have a verbal lease that is perfectly legally allowable in the state of Ohio. There's no law stating that you must write down your lease agreement. However, this is not best practice. It is also against the national quality standards to only have a verbal lease. In order to follow best practices and to follow the quality standards, you must have a written resident agreement that acts as your lease. So throughout today, I'm going to be speaking from a place of best practices and quality standards, which may go beyond what is legally required. And so for legal advice, certainly contact legal counsel, but today I'm really going to be focusing in on quality standards. And over these next couple of slides, I'm going to describe critical elements that must be included in your resident agreement and why they need to be there according to quality standards, as well as, to protect you. And so first, your resident agreement must be clear that the residence is a recovery home. I know it might seem redundant, but it is important to be very clear in your resident agreement that the home is a recovery home, and as such, you're providing housing for people in recovery from substance use disorders, and therefore it is not permitted for residents to use illicit drugs or alcohol either on or off the property, and that possession of illicit drugs or alcohol is also not permitted. Remember what you learned in the last session with the attorney. As the person who is writing this agreement, you have the opportunity to make things very clear. If you do not, any interpretation will be with the resident. So it is not advisable for you to take that risk. Also, for us, as part of our quality standards, you have to be very clear in your marketing and communications. Be very clear about who you are, what you're trying to do. And so putting that right into your resident agreement that it's a recovery home. And so for the health and safety of everyone living in the home, people are choosing not to use illicit substances or alcohol. And so it is very crystal clear right up front that this is what is expected because you're housing people in recovery, and that is the environment that they need. And you must, at minimum, reference your policies and procedures to ensure that there's understanding that the resident must agree to uphold the recovery environment and what exactly that looks like within your environment in order to maintain the agreement. And so this can include referencing your code of conduct, your medication policy, all of your other policies and procedures. So for example, if you have a resident handbook that outlines all of the policies and procedures that residents are expected to follow within the recovery home, you can reference that within your resident agreement. So again, your resident agreement clearly states that it's a recovery home. There's to be, no use of illicit substances or alcohol within the home, and that residents agreed to abide by the policies and procedures outlined in the resident handbook. And you can include the entire code of conduct and policies directly in the resident agreement. That is up to you. But we recommend referencing the resident agreement because anytime that you make changes to your policies and procedures and it is within the resident agreement, again, that acts as their lease, that's their lease. So you would have to have them re-sign it and go through all of that trouble and give people notice that there's going to be a new lease agreement. So what many people do is, reference policies and procedures that are outlined in, a resident handbook or other sort of document within their lease agreement, as in order to ensure that understanding of those policies and that people are aware of those policies when they're signing their lease agreement. And the first element that must be included within your agreement is being clear about who the agreement is between. And so the resident agreement should include the name of the landlord, which is typically the name of an organization. So, your organization, and then the name of the individual who's renting the property. And the agreement also includes the address of the property. And so, yes, if you own multiple homes and the resident moves from one house to another house, you would need to have them sign a new resident agreement with that new address. So it is just something that is very helpful for you to make sure that you're keeping track of if you own multiple properties, and perhaps if you have like a phase approach where people live in a level 3, then a level 2, then a level 1. That's great. It's awesome to have that full continuum, but you certainly want to make sure that people are, that you're updating resident agreements and that it's clear, where people are living and that they have a current agreement that matches their current address. So that way you've got all your legal I's dotted and T's crossed. And the next element of the resident agreement includes the length of time the agreement is for. And I know in previous sessions, we've discussed that length of stay of a resident is resident driven. And I want to be clear here that putting a term on your lease is not forcing residents to move out after a particular point in time. So having a week to week or a month to month lease or something of that nature, it's not interrupting your resident driven length of stay at all, because we just assume that that lease can be renewed, and our assumption is that it will be renewed until either party provides notice that they wish to not renew the lease. And so being clear about your lease term protects, again, both you and the resident, because, if you have an indefinite term, then the resident might think, oh, I can live here indefinitely. I never have to move out. And yeah, but if you're clear about that and about how that works, again, it can set those good expectations and can protect both parties. And you have several options for lease term. You can choose a week-to-week lease, a month-to-month lease, or a lease agreement for a specific number of months or years. It is up to you and your organization how you want to do the lease. There's no specific NARR standard that requires a specific term. And when considering how long the lease term is to be, you should consider a couple of factors. First is the longer the lease term, the more financial stability there may be for you. If someone is going to agree to pay you rent every month for a number of months, you can pretty much assure that you have guaranteed revenue for that period of time because they've signed a legal document that they will be paying you that rent for that period of time. And the drawback of a longer lease term is that you're obligated to provide them housing for the length of that lease term. And so if you want to end that lease early, you need to provide appropriate notice, come to a mutual agreement with the resident, or have a good enough reason for participating in the legal eviction process. And so, having a longer term, may not work out for you if you want to have a resident move out because you signed an agreement that said, you can leave this space for this amount of time. And a shorter lease term does not offer as much financial stability because the resident can move out quickly, you will have a vacancy, and no one will be paying rent. However, the notice requirement for a week-to-week lease is 7 days, which is much shorter than the 30 days required by longer-term leases. So this is something to consider when creating that lease term. Many recovery home operators use a week-to-week lease term for the very reason that the notice periods are shorter. And if you need to ask someone to move out, you do not need to give as much notice, and you can require them to move out more quickly and go forward with that legal eviction process a lot more quickly than you can if you had, a month-to-month lease or even an annual. And so certainly, again, consult legal experts to know exactly how much notice time is required for you for your lease agreement. And your resident agreement should also be clear about any financial expectations. This means any sort of fees, rent, utility fees, security deposits, any additional fees that you charge, like if there's a trash pickup fee or anything. You need to be clear about those and make sure that they're included in the resident agreement. If the fees are not listed explicitly in the resident agreement, it is not appropriate for you to charge the resident for those fees. So for example, many homes charge rent, but there might be another fee, such as trash collection. If residents are responsible for paying that fee, it must say so in the resident agreement. You cannot talk about only rent in the resident agreement, but then in the House Code of Conduct, add additional language about the trash removal fee. That fee needs to be in your resident agreement because it's a part of the financial terms of living in the home. Additionally, if you'll be charging resident late fees if they're late on the rent, that is allowable under the quality standards, but you must make sure it is spelled out in the resident agreement. Putting information on late fees into the House Code of Conduct or in the handbook without placing it in the resident agreement is not appropriate. The lease should also be very clear about when fees are due, and it's in your best interest to be as clear as possible. So use terms like the first of the month or every Monday at 12 p.m. If you use vague language like once a week, then someone might pay their rent on Sunday and then not pay again until 2 Saturdays later because they are technically paying once a week. Again, you have the option to make this very clear in your resident agreement to take advantage of that opportunity and avoid any confusion. And also consider if you want to be clear about how rent is to be paid. If it's expected that rent is to be paid to a specific person or a specific location, spell that out. You don't want residents to give their rent to a house manager or to another employee if they're supposed to deliver that rent payment to a specific office so it can be recorded appropriately. You also don't want residents to be just handing you payments whenever they see you because might not be ready to record that payment or payments might get lost. So if these types of processes and instructions are important for you, spell them out in the lease agreement. You must bring your rent payment to this address, and if there's specific terms, like you want it to be a money order or check or things of that nature, you can specify that out in the lease as well. So again, it's crystal clear how that works. And then finally, if you have a week-to-week lease, you should be collecting rent weekly to match the terms of the lease. We have heard from people where there has been confusion and the courts have decided in favor of the residents when they were trying to ask residents to leave the housing and they were collecting rent on a monthly basis, but the lease was so if they are paying monthly, then that implies that and you accept that payment, that could imply that that person now has the right to live there for the whole month. And so just to cover all your bases and again to set those expectations crystal clear, if the lease agreement says week to week, you're collecting rent on a week to week basis as well. So additional paperwork for you, but certainly can help you out in the long run to reduce confusion and again, make things as clear as possible. And we often get questions about sliding fee scales. And certainly sliding fee scales are appropriate and allowable. And one of the critical aspects of a recovery home is that it's affordable. And that may mean different things to a person at different points in their recovery journey. And so often when a person moves in, they may not have an income, but once they start earning an income, they're able to pay more of their rent. It is appropriate to have a sliding fee scale to most appropriately serve most residents. And however, you must have a well-documented process for doing so. And this is either spelled out or referenced in their resident agreement. This is to ensure that each resident is treated fairly. Many recovery homes simply base the amount off of the person's earned income. So for example, the recovery home will charge them a specific percentage of their income up to a certain amount until their income reaches a level where rent is less than a percentage of their income. So say the cost of having someone live there is, $200 a week. Many people cannot afford that. And so you might say, hey, until you get a job, you don't have to pay anything because your income is zero. But once you get a job, you're going to pay, 20% of your income until it's $200 a week. So if they make $100, they're going to give you $20 in rent for that week, so on and so forth until they're making enough to cover the entire cost of their rent. And so the home should collect copies of pay stubs or other documentation to demonstrate how they made the appropriate calculation and determination. And so other homes also allow residents to first take their income and then look at other financial obligations they have, such as child support, paying off debts, core fees, or other fines that need to be paid off. And they allow them to pay those off before they start considering rent payments. And as we know, for many residents, these fines can easily take up their entire paycheck, especially if they're just starting out, only working part-time or at an entry-level job. In these circumstances, the home would create some sort of worksheet where they can use to determine the amount of rent that is, and this worksheet is completed each time rent is due. So the important thing here is to really remember that you are documenting how you calculated the rent payment and keeping good records so that your process is fair and predictable. So residents can understand and predict how much they're going to owe based on their circumstances. The last thing that you want is to have a resident upset because they don't see, there's no logic in figuring out why they're paying $100 and their roommate gets to stay at the home for free. But if you've got a good system that says, here's the reason why, here's how we calculated it out, it can be clear, okay, this is why I have to pay this amount and someone else is paying a different amount. Just helps keep a friendly environment and people understanding what's going on and no one feels like things are being unfair. Finally, it's also appropriate to have time frames. Some homes allow residents to live in the home for a short period of time without paying any rent, and then they must pay rent after a specified time period. Again, this is acceptable, but it must be clear and consistently applied to all residents. So all residents who might move in get that benefit, and then it is clear and consistent about what's going to happen when that time period is over. And many recovery homes may receive a grant or other funding source to help residents stay at the recovery home without having to pay their rent right away. And all recovery housing operators must be careful to avoid kickbacks and inducement. A kickback is a situation where a treatment provider provides money or something else of value to someone in exchange for referrals. So if a treatment provider is paying you for the rent of a resident in exchange for that resident attending specific treatment services with that treatment provider, that can be considered a kickback and kickbacks are illegal. So you really want to make sure that you are not entering into such agreements. And if you are approached about such an agreement or you're considering such an agreement, highly recommend getting very good legal counsel with an expertise in these types of fraud and abuse laws because you don't want to inadvertently get caught in a situation where there are kickbacks happening. And so, we highly advise that you be very, very careful and avoid such arrangements where you are getting paid by a treatment provider as long as a certain resident is attending their treatment services. And also, if your organization runs both treatment and recovery housing, so you are doing both, it is illegal to require residents to receive specific services from your organization in order to get free rent. That can be considered an inducement, also, illegal. So again, if you are considering that type of arrangement for paying for your recovery home, get really good legal advice because that can be considered an inducement. And as far as the NARR standards go and the NARR Code of Ethics, maintaining free choice of service provider is something that is critical to the social model of recovery. And so we have to see that your organization is maintaining choice and that residents are allowed to choose where they get their services and supports. And if they are a licensed treatment provider and they're providing the service the resident needs, they must be allowed to choose that service. And you must treat all residents equally. You can't say, well, we'll only give free rent to people who get treatment services from our organization, but everyone else has to pay $600 a week. That is not along with the social model. And that may also be considered a kickback or an inducement. So again, seek legal guidance around that. And then some recovery homes may allow residents to stay at a home for a short time without making a fee payment, or the fee payment is paid by a grant from a county board, a court, or other organization. And so those grant dollars are not considered Medicaid dollars. They may be from a different funding source. So do your homework about where the money is coming from, but they may have a specific grant specifically to take care of the rent and fee payments at a recovery house. And so this is acceptable. You can, allow somebody to live in your home if you've got a grant for that, but you must be clear in your resident agreement how long a resident may stay without paying any fees. If you leave this open-ended, the resident may assume that they can live in the house forever without paying any fees. They can always live there rent-free. And now if your organization is like a church ministry or something and the church is offering that's what they're offering, and they don't ever want people to have to pay rent, then that's fine. You can do that. But for many people, the goal really is to have residents eventually come to a situation where they can pay rent. And so you want to be clear about what your expectations are around that. And so, for example, if residents are eligible to have their fees paid as long as they're out of work, be clear that once employment is secured, they'll have to begin paying rent. Be clear what the timeline is to have to begin working. It is your best interest to be reasonable. Again, it is up to you in a quality recovery home to help them engage in efforts to find employment. And so you will be the one helping them, developing a list of employers to apply to, maybe helping them with a resume or interviews or things of that nature. So really look at the current job market, what wages are being paid, and other factors. And then you can, determine like, hey, we really want you to find a job within X amount of time, and so you can begin to pay your rent. And then similarly, if a subsidy is time limited, examine if you really feel like that resident will be able to pay rent once the subsidy is over. So many subsidies run out, and the resident may need to start paying their own fees because that the grant payment that you got or the specific subsidy program is only for a limited amount of time. And it must be made clear to the resident before they move in that the expectation is that they will find income and that they will be able to start paying rent after that subsidy is over. We don't want to see people being like, well, I'm just going to live here for the time period of the subsidy and then move out because then I'm no longer getting free rent. We want it to be clear that that subsidy is just there to help them through a brief time period, and then that way they can then they'll be their expectation is that they're going to stay, that they're going to continue to engage in their recovery journey, even though their subsidies ended, but that the house will help them find a job or apply for other programs so that way they can be able to pay their rent after that time period is over. And of course, these are factors that you should not wait to consider, but be thinking about and planning about from the beginning. We want residents in our recovery homes to stay as long as possible because the longer they stay, the better outcomes that they have. And so making sure that there's a plan in place to help them with rent is a part of helping them stay in the environment and ensure that that subsidy is put into best use and is invested most wisely. I'm seeing some questions here. What do we do if a client wants to move before the lease is up? That is a very good question. We are going to cover that a little bit later in the slides. So please hold on to that question and we will address that in the future. And then can you make clear what a kickback is? I do not have the formal definition set up in front of me, but but any sort of arrangement where you are getting anything of value in return for a referral to a treatment organization can be considered a kickback. And so for purposes of recovery housing, if a treatment provider is paying you money, that you use for rent for the resident, if they're giving you that payment, and then in return, that resident is going to their treatment services and is using their treatment services, and then they're billing Medicaid, that can be considered a kickback. And so those are the things that we want you to be aware of. And then I am not an attorney. I'm not qualified to give you legal advice, but if you see those types of arrangements, if you're approached about those types of arrangements, be very careful and seek legal guidance because you want to make sure that you have a safe harbor or some other legal mechanism to make sure that you are not violating the law and that you are not engaging in kickbacks, because that is a very serious offense. And so we just want people to be aware of that, and then of course seek legal guidance on your individual specific circumstances. And they ask if they're a program that is paying the first and back month rent. So again, anytime you're receiving anything of value in return for somebody engaging in a specific treatment service, that I would ask an attorney and I would say, hey, does this look like a kickback to you? Does this look like this is something that we can do legally? I can't give you legal advice, so certainly take your individual circumstances to an attorney and somebody who does know about Medicaid laws, anti-fraud, kickbacks, and appropriate inducements. Because you want to make sure that everything you're doing is above board and that you're not inadvertently breaking law. Okay. So the resident agreement must also contain any information about security deposits. And so typically recovery homes do not charge security deposits. It is because many people seeking recovery housing do not have the resources to pay for a security deposit. So if you require one, you might be limiting the residents who are able to live in your recovery home. However, it is allowable under the NARR standards to charge a security deposit if you follow the law and the security deposit terms are spelled out in the resident agreement. And if you do decide to charge a deposit, language on this must be included in the resident agreement. Again, you cannot include it in the application or the House Code of Conduct and not include it as well in the resident agreement. All financial terms must be in the resident agreement. And the resident agreement must be clear about the terms and conditions that a person may get their security deposit back. And so again, consult legal guidance and make sure that you're in alignment with all laws regarding such deposits. And another item that must be listed in the resident agreement is information on resident property. Unfortunately, residents sometimes move out of recovery housing quickly and leave some of their belongings behind. If your resident agreement should be clear about what happens if belongings are left. Again, be sure you are in compliance with all state, federal, and local laws on what expectations there are around landlords and personal property that's left behind. Quality standards require that you keep property for a reasonable amount of time and that you allow them a reasonable opportunity to retrieve their belongings. It is up to you to set that amount of time, but it must be clear. And it is also best practice for you to have a process in place and a place for you to securely store items. This will help you avoid potentially bad situations where someone accuses you of stealing their cell phone or their computer or whatever, or an expensive pair of shoes or an expensive outfit or anything that they might have that might be of value. So you want to make sure that you have a process in place to appropriately store the items and then secure them until that person is able to retrieve them. An endorsing agreement must also contain information about how the agreement may be terminated. It must allow for either the operator or the resident to initiate termination. And I know many of you are probably thinking a good deal about how you as an operator, you might want to have someone move out. How do you do that? How do you terminate the resident agreement? By giving appropriate notice or using the legal eviction process. And many recovery homes are really excellent at spelling out about how the operator can do that and go about doing that legally. However, the resident must also have the ability to end the resident agreement. And so hopefully for most residents, this will mean a process where the resident is ready to move on to another home, such as their own apartment or moving in with family or friends. And as far as the resident agreement is concerned, you'll need to have a process in place for them to notify you that they'll be moving out and ending their lease. And it is a very good idea for you to have to get that in writing. So you have, and you can even have a standardized form to help people out saying like, hey, we're notifying you that we are not renewing our week-to-week lease and all of the details, so forth. And additionally, we hear stories of residents leaving the home and not returning without telling anyone where they're going. At what point do you consider them to have abandoned the home and their property? And are you going to start, securing their property, especially if there's a situation where they have a roommate or something where you want to make sure you're securing their property so nothing happens to it. And at what point are you going to consider the property like abandoned, where you consider them to have moved out because you haven't seen them. So you want to make that clear in the terms of your lease as well. If what that looks like if you consider them moved out, but they didn't give you any notice. And then finally, if someone is unhappy with living in the home and wishes to move out, how do they let you know? Especially if they are in the middle of a lease term where they just don't want to wait until the end of the week. They don't want to wait, or if you have a month-to-month lease, they don't want to wait until the end of the month. Are you willing to offer them a refund under any circumstances? I bring this up because in many circumstances, when a resident is not enjoying living the recovery home and they're not meeting their goals, they may be causing disruptions to others in the housing community. And under landlord tenant law, you must give notice and follow the law. And so that means that someone who does not want, that may mean that someone does not want to move out, but may not be able to continue to live in the home and be disruptive for a period of time, even if you have a week to week lease. So for a week to week lease, it's much shorter, but there's still a period of time when they may be living in the home. And so in this event, you may come to a mutual agreement to end the lease early. And oftentimes providing someone with a prorated refund as well as warm referrals to other places where they can live or get additional care or meet their needs may help you both mutually decide that it's in everyone's best interest to end the resident agreement early. Again, the decision must be mutual, it must be free from all coercion, but providing that refund can really help residents, come to that decision and agree to move out because they will have some resources to find a new place. And that might be something that might be holding them back from moving out more quickly is because they've already paid their rent to you and they may have very little resources to move out. And if you are concerned about needing to ask residents to leave, please refer to all of our previous sessions on how to create a positive environment. Prevention really is the best strategy, and engaging in all of these activities will greatly reduce the chances that someone will be unhappy and wish to leave. However, I'm not going to lie to you, circumstances do happen. Recovery homes that make it as easy as possible for residents to end the agreement, allow them to get some of their rent back and their security deposits back, and remove their property in reasonable amounts of time and give them warm referrals and resources, have the most success in handling such situations amicably without going to court and without causing major disruption to everyone else in the house. It is not a situation that anyone finds pleasant, and all other aspects of these trainings we hope will help you learn to keep these situations to a minimum. But if a resident is not working out and wants to leave, making it easy as possible for them to do so is a good idea for both you and the resident who may wish to return to recovery housing. Even if it's not your recovery home, they may wish to try it again in the future. If you do need to use the legal eviction process, we encourage you to seek legal guidance to ensure that you are in compliance with Ohio Revised Code, Chapter 1923, the section on Ohio eviction law. All right, and somebody asked, what if it is 4 months before the lease is up, and you want to ask, I mean, it depends. If the resident is choosing to leave and they want to leave, it is up to you if you are going to again mutually agree to end that lease term early. Like, you both can always come to a mutual agreement, and again, we highly recommend you get that in writing, that you're ending the lease agreement early. And so it's up to you as an organization if you want to allow people to do that. Most of the time, it's in your best interest to allow them to leave early and get out of their lease early, because if they don't want to be there, they might be disruptive to everyone else. But it is up to you. If you are asking someone to leave 4 months before the lease is up, you might be stuck because you have a legal agreement which says that they can live there, and you would have to give them appropriate notice and then also engage in and have a good reason under the law, under eviction law, and go to court and go through that whole legal eviction process to have them removed from the property. So, and again, seek legal guidance on for the legal questions around there. But as far as quality standards go, we want to see if a resident's not happy and they want to leave, that you provide them warm referrals, you provide them information and resources, but it is their choice to leave. And making that process simpler for them, if that's their choice, is probably in both of your best interests. So that way, hopefully they'll return to recovery housing when they're ready for it. And another item to be addressed in the resident agreement is any change in terms. And so including information how terms can be changed can also be an important part of your resident agreement. And so whether you include entire copies of your policies in your agreement or you're including them by reference, it's a good idea to tell people the process for any changes. And so in order to meet quality standards, you must notify residents in advance of any changes to your policies and allow time for discussion and for them to ask questions and provide feedback. So remember, the recovery home is their home, and under the social model, residents themselves are primarily responsible for living a code of conduct and enforcing policies and procedures. Changing them without resident notice does not allow for residents to engage in their environment in this way. And so changes related to the changing of fees are especially important for residents to know, understand, and prepare for. So finally, the document must be signed by both you and the resident and have the date of the signature included. And also here too, once they sign it, give them a copy. And it's highly advisable that you let them know that this is a legal agreement and they should keep the copy safe. So if you've provided them a safe or lockbox or anything to keep items secure, we suggest that they store a copy of their lease agreement in there. But they should get a copy, and so they have it, and all of the terms are within it. And again, that's a good idea for you because instead of them, kind of making up in their head what they think they signed, they can always look at the actual document and see, okay, I did sign this. This is what it says, instead of kind of making things up in their head because they don't have a copy. Also, if you have the ability to, and it works for that particular resident, you can scan it and send it to them electronically, so they have it electronically. Any way to make it easily accessible to get this document and all of your other policies is a good idea, because you certainly, if they don't have it in front of them and they have questions, sometimes people tend to make things up. And so you want them to have easy access to what requirements are and what they're supposed to do. And then finally, when you're reviewing your resident agreement, there are some items which you are not allowed to include under the quality standards. And these things include, you may not require residents to waive their legal rights. As we learned from our previous session, such waivers don't mean anything. Residents cannot waive legal rights. If it was as simple as saying, like, just sign here and say, that you're waiving all of your tenant rights to live in this place, every landlord would, and no one would have any tenant rights. It is not possible for people to voluntarily waive their tenant rights. And so for us, under the quality standards, we require that people have appropriate marketing communication and that they be honest and forthright in those communications. And so therefore, we do not allow recovery homes to have such language in their documents, because that is falsely marketing that they're not a tenant and they don't have such rights when they do. And also, you may not require residents to receive treatment or services from specific providers. Again, recovery homes must allow for free choice of providers. And again, contact legal advice for things like inducements and kickbacks. You want to make sure that you are not engaging in any of those illegal activities. And also, under the social model of recovery, having a free choice in your service provider is something that that we want to maintain under the social model of recovery. You may also not require that residents move out after a specific amount of time. And so, yes, you just went over lease terms, but that term is renewable. So saying that you may not live here longer than 60 days, things like that, that type of language cannot be in your resident agreement. You may also not require that residents volunteer for you. And we're going to go over volunteers and what that means in recovery housing and some tips on that a little bit later. But you cannot require that they perform volunteer work for you. And of course, you can ask residents to engage in volunteer work, but you can't say you must do that for me. Similarly, you must not require that residents be employed by you. And we'll go into, again, employment and volunteering a little bit later in the session, but as far as the resident agreement goes, there can't be any language that says that residents must work for you or be employed by you or an associated organization. And then also, you may not have a requirement that residents fundraise for you or make financial donations to you. Again, if they are giving you money, that They're getting rent in return. That is a rent payment. It is not a fundraiser. It is not a donation. It is a rent payment. And so for the purposes of our quality standards under clear and appropriate marketing, we have to call things what they are. And so a rent payment is a rent payment, or a fee payment. It is not a donation. All right. And so now that we've discussed the essential components of the resident agreement, I would like to spend some time on some related topics. And so these are separate because I want to be clear that these types of things are not generally spelled out in the resident agreement themselves, but they are things for you to consider in order to, um, in order for when we're thinking about moving in and moving out of recovery housing, in order to be successful, you might want to engage in some of these things. And it's kind of related to the resident agreement process. And so the first thing is thinking about move outs and terminations. And so when it comes to helping a resident who's ready to move out and make that transition, it's a good idea to have a plan in place to help them. And so I'm just going to ask a discussion question here, just to get your juices flowing. And so into the question box here, type in, what are some ways that you can support residents who are moving out? So as they tell you, hey, I think I'm ready to move out, what are some things that you think you can do to help that person? All right, people said help them find a place to move, help them actually move their stuff, help them pack and things. Um, Uh, Again, see if they need assistance with packing, give them a list of places they could move. The resources for furthering their treatment and transportation, right? So community resources they might want to be connected to. A recovery plan. Yeah, so talk with them about that recovery plan. How are you going to continue your recovery plan? Help them make a plan for that. Um, yeah, help them with boxes, getting a place, and referrals. Yeah, so referrals to other community services and things. Yeah. So those are all really good things. Yep, assistance with getting utilities turned on and things like that. Yeah, those are all really good suggestions. And so I think first, when it comes to helping a resident move out, is a really good idea to have a plan in place. And so, like many of you mentioned, it's the first thing you think of is like, oh yeah, you tell me you're ready to move out. Do you know where you're going? And then, so it's a good idea for you to have a list of local landlords that you know who are willing to rent to alumni of your program. And so you can gain knowledge about different housing programs that are available. We know, especially in this market, it is extremely difficult to find places to rent. And oftentimes, people in recovery from substance use disorders may have criminal histories or poor credit histories. And so, really, maybe developing a relationship with a local landlord and saying, like, hey, this person's completed our program. We're aware they have a criminal history, but they're we think they'd be a good tenant. That you can really help ease that transition and help people out if people are willing to hear you. But we know, especially in this housing environment, it's extremely difficult for anyone to find a place to live, and then people with substance use disorders may struggle even more. And so churches and other community organizations might also offer resources to help people become established with things like furniture, cleaning supplies, or like you were saying, getting your utilities turned on. Helping them do that work to see, like, hey, do I have any back utility bills somewhere else that I need to pay off first? Like, and really having that plan. So before they're like, okay, we've signed, we're moving out on the 31st, they know all of these things that they're going to have to deal with. And then somebody else here said their recovery plans. Integrate their plans for moving in their recovery plan. So help them identify the things that they need to do to move out. You can help them develop a budget. Do they have enough money for the security deposit and for first month's rent? Do you think that they make enough, or do they think they make enough money to pay the rent for their new place on an ongoing basis? Does their new place have transportation to work? Does it have parking? Is there an additional parking fee they need to think about? What are the utilities like? Do they think they'll be able to afford those utilities? And so really, helping people like think through all of those things and not necessarily being like, oh no, you can't move out, but being like, yeah, it's good. You're having a plan. It might take you some time, but this is the plan that you're in to help you move out. And there might be some community resources that can help with some of those things. And somebody here mentioned HEAP. So HEAP is something that they can apply for utility assistance, to even help them even pay back past utility bills. And then, of course, when that time comes, you have a set form and plan for them to remove their belongings and sign off to tell you all their belongings are removed. Many people mentioned you can help them pack, you can help them move the boxes. And if you have keys, have a process in place for them to return the key, and you document that happened. A lot of people use codes, so have a process in place to change the code, all things like that. And then we have heard from many recovery housing operators that this transition of moving out can be stressful, and residents may experience heightened anxiety, and some residents may have experienced disruptions in their recovery right before what might otherwise have been a successful move out. So we recommend maybe checking in with them more frequently to see how they're feeling and provide additional peer support or connection to a counselor or additional treatment provider as they need. Moving is a big transition for anyone, and certainly there might be a lot of feelings and stress, and so providing maybe that additional peer support and letting them know that it's okay, that a lot of people experience that, and it's okay to ask for a little additional help if they need it. And then some operators also recommend, like if they're moving out, like putting a day on the calendar to have them come back for a house meeting, a dinner or coffee. So that way it's like, yeah, you're moving out, but we're going to see you on Tuesday at dinner, and we want to hear all about your new place and how things are going with you. And so that way they know that even though they've moved out, they still are connected to their recovery community. They still have friends. Those relationships that they developed within the recovery home are still there, and they can still reach out if they need anything, and you're still there for them. And so having that set time on the calendar can really help people feel like, okay, this is going to be an easier transition because I'm moving out on Sunday, but Monday or Tuesday I'm going to have coffee with my old roommate and it's going to be great. I'm going to see people again. So those are just some recommendations to ease the transition of moving out and help that be really, really successful. And so for terminations where it's the operator making the decision for someone to move out, it's important that you follow not only landlord and tenant law and eviction law, but also quality standards. And so ORH, we often get concerns from residents who have been asked to leave recovery housing. And if this is the case and we get a concern and we're reviewing it, we'll be asking you for documentations of your reasons for terminating the agreement. You must have documentation that demonstrates that that person was a risk to the health or safety of other residents. And you must also document all of your attempts to assist that person and address any problems or issues that you had with them. So you must also document that you provided that person with warm referrals and resources. And so remember from our previous discussions, handing them a list of phone numbers is not sufficient. You must document that you've tried to make phone calls, you've tried to find the person another place to go, and it was either their decision to use that resource, and so they decided to use that resource, and that involves them moving out, or not use the resource. And residents should not be exited into homelessness with only a list of phone numbers. That is against our standards for you putting that best interest of the resident forward, and it's also not a good neighbor policy. One of the number one things neighbors complain about bad recovery homes is that people get kicked out, and then all of a sudden they're homeless on the street with a garbage bag filled with their belongings, and there's no place for them to go, and so they cause a lot of disruption in the community. We do not want to see that. And so you need to make every effort to find resources and places for this person to go. And similarly, if a person is being asked to leave because they did not pay rent, you need to document all of the steps that you took to help them. Again, this is not legally required, but under our quality standards, it is up to you to do what you can to assist that person in getting into a financial position where they can pay the rent. And this is especially true if they were allowed to live at the home for free, and then you start charging fees. We do not want to see you implementing fee scales as a de facto way of having residents leave your house. The plan and intention of everyone moving into your house is that they are going to stay, and they're going to stay for as long as they need to. Certainly for at least 6 months, because that's when we see a lot of really good outcomes. But we want to see people stay for a year, even 2 years, if that's what they need to get solid in their recovery. Again, the longer they stay, the higher the outcomes they experience. And so the plan should always be to have them stay for a long time, and not to use the implementation of fee schedules as a de facto way of getting people to move out more quickly. And so if someone is not paying their rent, we want to see that you exhausted all resources and that keep that person safely housed. We do not want to see someone who's active in their recovery being asked to leave a safe and supportive environment simply because they do not have the money to pay rent. We need to see you did all that you could to help that person find a job, get income, or get other supports to help them pay their rent. And here on this slide is a reminder of number 14 in the NARR Code of Ethics. You are ethically obligated to provide an environment in which each resident's recovery needs are the primary factors in all decision making. And so that means that their needs is your primary factor in your decision. It's even above the financial health of your organization. And so again, if there's someone who's doing well in their recovery, they're following all your rules and policies, they're just not able to pay rent. Their needs of having good, safe, stable housing is the paramount in your decision making, instead of the financial, the financial interests of your organization. And while it's not a component of your resident agreement, it is important to note that NARR standards also require that you have an appropriate counting system. It is up to you what system you choose, and we have recovery homes that are in many different types of organizations, big, small, whatever, but you must have an appropriate accounting system. And there are many low-cost options, such as FreshBooks, or other types of options that are out there. You can use those if those are what works for you. And there are also really sophisticated programs that you can purchase. And so we recommend getting with an accounting person or a CPA or some other sort of professional, and seeing what they recommend for your organization, your size, and all the different businesses that you might have. And so in order to meet the NARR standards, your system must be in a place that allows you to record resident fee payments and provide residents with a receipt. So anytime a resident pays you, you should be able to provide them with a receipt that they made that payment. You must also be able to produce a statement of account for the resident upon request. And so this statement of account should be able to detail all of the charges and fees paid by the resident, as well as tell them if there is any outstanding balance owed. And so your system must also be capable of tracking any payments that are made for that specific resident on their behalf. So if you are receiving a subsidy for a specific resident, you must be able to record the payments made and see those on the statement of account. And so whether this is rent being paid on their behalf by, say, a county board, where they say, hey, this person's eligible, we're going to give them a specific amount of rent payments, and so you can apply that to that specific person. Or if a parent or other loved one is paying their rent for them, you collect that and then you record that within their statement of account. And so you should be able to print that out and upon request and see all of those payments that have been made. And it is critical that you keep good documentation of your efforts. And so, like I stated previously, you need to demonstrate that you've done everything that you could to assist the residents and helping them pay their rent if you are ending a resident agreement or filing for eviction. This goes beyond landlord-tenant law, but it is in the NARR Code of Ethics that you do this. And for us, we often get concerns from residents who are asked to leave, for non-payment of rent or for other reasons. And in those circumstances, if we get that concern, we'll be contacting you and asking you to show us all of the steps that you took to help that particular resident and that you are following the quality standards. And so for us, we would be asking you for documentation that, of their recovery plan. What did you do to help them in their recovery plan? What did you do help connect them to resources in the community? If they were having an ongoing issue, what did you do to try to engage them? And we need to really see, what your logic was behind me asking them to leave. And if you're asking them to leave for non-payment of rent, again, we want to see your documentation of all the efforts and attempts that you made to help them, gain an income, whether that's applying for assistance programs or for helping them find a job or other resources before you engaged in that process of terminating their resident agreement and asking them to move out. And so it is in your best interest to keep all of that documentation. So that way, if we get a concern from a resident, we can reach out to you and say, hey, we've got this concern. Tell us your side of the story. And then you can show us all of that documentation that demonstrates that you were in compliance and you did everything that you were supposed to do under the standards. And the resident agreement is an essential document, and both you and residents must understand what the agreement is and what it means. And it is a critical document, and it's very clear that be well written. But it's also in your best interest to make sure residents take the time to read and understand it, because it can cause everyone issues in the future if they don't really understand it. They're just desperate to move into the house, and so they just sign anything you put in front of them. That is not a good situation for you or for them. And so we've talked to several operators on best practice strategies around making sure people understand what they're getting into when they are reading, they're going over their resident agreement. And so the suggestions here are to first allow the resident to make sure they're comfortable. This is especially true if a resident has recently been experiencing homelessness, if they're recently exiting a treatment program or exiting incarceration. They just might need a minute to get something to eat or have a drink of water or go to the bathroom or even just sit and rest for a minute. So really, giving somebody that time to make sure they're in a good place to have their brain process information can be extremely helpful, especially if someone is coming from those types of circumstances. Also, making sure that the resident can read the lease agreement to you, so have them read it out loud. And for many, especially if people might struggle with reading comprehension or reading, it can be a good idea to have a peer engage in that process with you, so that way they can ask for help when they need without any shame or any embarrassment. But again, you're making sure that they understand fully, and then they can also ask that peer any questions about what it's like to live in the house and what specific things mean. And so I suggest you read out loud your resident agreement, see how long it takes you, and then double that amount of time. And that should be a baseline of an amount of time that you should set aside for going over your resident agreement. I know it's a long time and you got 8 million things to do when someone's moving in, but it will certainly, I believe, save you a lot of headaches in the future if you do take that time to ensure that good understanding from the beginning. And then finally, your policy must match your practice. So remember, this agreement is a legal document and you should treat it as such. So be sure that you are upholding all components of the agreement and that you are enforcing the provisions of the agreement fairly across all of your residents. And so not doing so can get you into some serious legal circumstances that you rather avoid. So be sure to carefully read your entire agreement and make sure you are willing to uphold everything in that agreement. Because if there's anything in that agreement that you don't enforce or that you don't uphold, it could put the rest of the agreement in a category where things are suspect, and you don't want that to happen. So just like with all of your policies and procedures, read them carefully and be prepared to enforce them the way that they are written. Your policy must match your practice. And I'm going to pause here for a minute just to see if there are any questions. I've been kind of answering them going throughout, but if I missed your question or if you have an additional question, I just want to pause here for a second and see if there are any. All right, I'm not seeing any, but I'm trying to keep my eye on this questions box. So if you have any, drop them in. And so moving on to our next topic, which is paid work agreements. For us, a paid work agreement is when a recovery home hires someone who is considered a resident to do work for them. And so the resident may either get payment or a discount on their rent or both. This is another issue that you need to seek really good legal guidance on. Again, today I hope to give you the broad overview so you can issue spot and drill down and have really solid, short conversations with any sort of legal guidance or expert, save you some time and money. But there is no replacement for that. And rent is considered a taxable benefit in the state of Ohio. And so if you are offering someone rent, like discounted rent or free rent in exchange for them doing work, you want to make sure that everything is above board with your taxes. And so you want to contact a tax expert as well. And many recovery homes simply do not want the additional legal risk or of having to do additional record keeping in order to have current residents work for them. And so therefore, they simply do not hire residents to work for them while they're living at the house. And of course, alumni of your program can become staff and often do, but for many recovery homes, they do not allow current residents to become paid staff members. And that's okay. It is up to your organization what you want to do. But there are also many recovery homes that do allow residents to perform work for the organization or another associated organization or business. And you must have and if you do this, you must have a policy that clearly states that paid work is entered into voluntarily. Residents are not forced to work for you. Um, and uh, and if they do choose to work for you, it must be a free choice, and they must have the ability to work elsewhere if they choose. So it's like any other employee relationship. They choose to work for you, they go to work for you. If they don't want to work there anymore, they can leave that job. It does not impact their housing. And work must be paid at fair market rate. This is not minimum wage, it is fair market rate. So for example, if a resident is being hired to perform construction work, that type of work is generally much more highly paid than minimum wage. And so offering that person and only paying them minimum wage is not acceptable. They must receive fair market rate for their work. And the work should also not interfere with their recovery goals. And so again, you are taking on additional responsibility as their employer to make sure that any work assigned to them is not interfering with their recovery goals, and their recovery must also be allowed to come first for the resident. And also, residents who work for you should not get other special benefits or treatment other than their fair payment. So yes, they're getting paid, and residents who do not work for you don't get paid. But for example, you cannot say, well, if residents work for us, they get single bedrooms, and the residents who work elsewhere get the double bedrooms. That's not appropriate. You know, everything else within the home must be the same, but the people who work for you, of course, are just getting their fair salary, you know, and are treated like any other employee. And many recovery homes see value in assisting residents with employment as a recovery goal. And notice that connecting residents to employment and job training often improves recovery-related outcomes. And therefore, they've started employment programs and teach job skills. And that's excellent. But you must be sure that you're keeping some separation between your employment program and the housing program. And so for a fictional example, a home starts a social enterprise where people living in the recovery home learn catering as a job skill. And so they have a social enterprise catering company. A resident moves into the house and starts working at the catering company that acts as the social enterprise. But after a while, the resident realizes how much they really hate working in food service. They just can't stand it. And so they leave that job training program and they enter into another job training program run by a different organization where they're learning a different skill. Now the residents they're still fulfilling their goal of engaging in job training, and they're still employed. They're still paying their rent, and they're otherwise engaged in all of the recovery-oriented programming in the house. So they should still be able to live in that recovery house. Just because their experience with your particular job training program didn't work out doesn't mean that they should lose their housing just because they figured out they really hated food service and catering. And so similarly, if something happens at the employment situation where a resident loses their job, they shouldn't automatically lose their housing. So say the resident was extremely rude to a customer or something like that, or something happened and you were like, okay, we have to let this person go from their employment. That doesn't mean that they should automatically lose their housing. What you should do instead is like, okay, what do we learn from that situation? How do we do better? And how do we find you a different training program, a different job? that sort of thing. So that way they can continue in their recovery, even though they're not a part of that specific job training program. And recovery housing programs may also require that residents volunteer as a way to develop job skills, work on soft skills, build relationships that can lead to employment, and in general, keep residents busy, even if they may not be able to have employment for whatever reason. And residents should be able to choose where they volunteer. So for example, if you have a relationship with a local thrift store, and residents may volunteer for the thrift store if they're looking to meet their agreed upon service hours, but if the resident chooses, they can also volunteer at the Humane Society to walk the dogs, or volunteer at the local library if they're more interested in engaging in that type of volunteer service. Again, you can say you have, as a part of our organization, we volunteer, but you cannot force residents to volunteer for you. As you can imagine, we have these policies are here for a reason. I'm sure you've seen lots of news stories from other states around recovery homes that essentially turned residents into indentured servants, making profit off of residents doing work in exchange for, giving them, oftentimes substandard housing. And so all of these standards and things exist to both protect you legally from that type of situation, but also to protect residents and make sure that, residents are treated with dignity and respect, and that they're not taken advantage of within a recovery housing environment. And so just a note on having volunteers at your organization, you can only use volunteer labor if you are a nonprofit. If your organization is a business, people cannot volunteer for you. So make sure you are aware of that. You don't want to get in trouble legally. So if you are a nonprofit, yes, you can have volunteers, but for-profit businesses, volunteering is not a thing. The activity that volunteers do must be less than a full-time occupation. So no volunteer should work for you for 40 hours a week. And that services for volunteers are offered freely and without coercion or pressure. So telling someone that they must volunteer or they need to move out is considered pressure. So you are not permitted to do that. Also, the services provided must be typical of volunteer work. And I know it's frustrating, but in the law, typical is not really defined. So really consider that and consider, how much risk you want to take on. So if a job is typically something that you would pay someone to do, it's probably not appropriate for volunteers to be doing that work. And then regular employees are not displaced for a volunteer. So you cannot fire your building maintenance person and replace them with a resident volunteer to fix all of the things that are wrong with your buildings. And then volunteers also do not expect or receive any benefit. And so it is important to note that housing, either free or discounted, is likely to be considered a benefit. And this is from our legal compliance trainings that we had. Again, I'm not a lawyer, can't give you legal advice, but from attending those trainings and passing along this information that, from other legal experts, the advice that they've been giving out is that it's a good idea to keep volunteers separate from employees. So you have job descriptions, position descriptions for employees, and you have volunteer descriptions that outline what activities volunteers do. And so it's very separate. And then you have separate policy manuals for employees and volunteers. And so, of course, for volunteers who volunteer with you regularly, they probably should uphold a code of conduct and do all sorts of things. But handing them your employee manual might get you in trouble, because that might imply that then that they are eligible for all of the benefits and things that you give employees, like wages, and that sort of thing, when volunteers do not get those things. So it's a good idea to, if you have these regular ongoing volunteers, that you also have a volunteer policy that you share and that you give to people, so they understand, hey, they're not employees, they're not getting the same benefits as employees. And then finally, as well, just no coercion, as well as no exchange of benefits in terms of people volunteering for you. It should be given freely, and that's what volunteerism is. And so, of course, one of the most popular questions we get about paid work agreements is about your house managers. And these people might have all sorts of different titles in recovery housing: house manager, resident leader, all sorts of titles. Each home is run differently, and And unfortunately, it's just not possible to provide blanket advice on this topic, which I know is really, really disappointing for you. If you were looking for to say, hey Danielle, this is the template, this is exactly what you need to do. I'm sorry, the answer just is not that easy because each organization really is different, and each position is different in what you're requiring them to do. And so on this next slide, here are things that I highly recommend that you outline before talking to your employment expert. And this will help make your conversation much more focused and help you get really solid advice. And so think about what type of organization you operate. Are you for profit, nonprofit? What type of for profit? All of that. What are the specific want to see performed by the particular person that you're thinking of, your house manager, resident leader, whoever? What specific things are you requiring that they do? And then think about how many hours is this person going to be considered to be at work. This is especially true for people who live in the home. So are they considered to be at work whenever they are in the home, or are there only specific, times and situations when they are considered to be at work versus they're just living in the home? And is this person required to report to work at specific times of the day? So are you going to be very specific about you must be present at the home between 8 a.m. and 5 p.m. or between 5 p.m. and 8 a.m.? Is that something that is required? They have to report somewhere at a specific time in order to do these specific. And then how do you plan on compensating them? We talked a lot about, rent or free or reduced rent being considered a benefit. Are you also going to pay a salary? Are you going to give a stipend? Were you considering them being a contract employee? What were you thinking as far as this is how I would like to pay this person? And then how much freedom do they have to make decisions? Is it a very much a prorated, you do exactly this, you don't have any decision-making authority, or are they very highly trusted and they make the decisions? We give them a list of tasks that they're supposed to do, and they have the power and the authority to make the decisions. And so all of these factors, think through it, plan through it, and then take that information to your employment expert, and they will probably ask you a lot of these questions. You'll have really good answers, and they can give you some really good advice on how to structure that relationship that you're going to have. And be sure just that you're following all employment, tax law, and charitable laws. You really want to make sure you're doing that. And then for the NARR standards, all employees must have a position description, or if they're a contract worker, an agreement that spells out what they're responsible for. And so for us, we've got specific things that we need to see happen at different levels of support. And so when we ask you for your position descriptions or contract agreements, we're looking to make sure that there is a person who is responsible for completing specific tasks within the recovery housing environment, and that is assigned to a specific person for either it to be considered a level 3 supervised environment or a level 2 monitored environment. And so we want to see these specific details. Also, we want to see that it's appropriate for recovery housing. So going back all the way to our very first session on language within recovery housing, if you turn into us job descriptions that say clinical counselor, and it's my job to provide clinical counseling services, we're going to say, hey, this looks like it's a residential treatment center and not a recovery home, because clinical counseling is a clinical service. We want to see things like it's this person's job to make sure the recovery environment is being upheld, to provide peer support, to monitor the recovery environment, to help empower residents to manage the code of conduct. Those are the things that we want to see for recovery housing. If we see way too many tasks on these position descriptions that look like these people work in a clinical environment, then we're going to assume that the recovery home is a clinical environment because that's what you wrote down in your position description. So again, take a look at them and be very careful about making sure that these position descriptions are reflective of a recovery housing environment as opposed to a clinical treatment environment. Staff must also be appropriately trained. And so all staff must be trained on the social model of recovery and on the basics of recovery and addiction, and as well as in your individual organization's policies, procedures, and philosophy. And all staff who interact with residents must also receive regular performance reviews, receive social model-oriented support, and ensure that they are supported in their own health and recovery. And so it is up to you as an operator to keep documentation that your residents are trained, and that you've provided that training, as well as keep documentation of any performance reviews, and on any coaching that you provide to your staff, and ensure that they're supporting their own health and recovery. So for example, if we get a concern from a resident who says a ex staff member was really rude to me and I reported it, you want to make sure that, yes, here's the documentation of the conversation that we had with that staff person. Here's how it showed up on their performance review. Here's how we're monitoring and making sure that everyone who works directly with residents or has responsibilities with residents has their performance evaluated, and that is looked at by the organization. So we want to see that you guys have documentation that you've been doing that. And then level 3 recovery environments are required to have a code of conduct. We highly recommend them for any organization that has paid staff, but it is required for level 3s. And in the staff code of conduct, it should cover things like appropriate boundaries with residents, including romantic relationships, prohibiting romantic relationships between staff and residents, as well as financial relationships. So no borrowing or loaning money or things of value between staff and residents. This code of conduct should also be clear about how staff are expected, any expectations you have around posting on social media, in keeping resident rights and confidentiality. You want to make sure that's spelled out in your staff code of conduct. Also, discrimination, abuse, and harassment. What are your expectations around those? What behaviors are considered, unacceptable? Expectations around regarding recovery principles, especially for in a recovery housing environment, you want to outline, any sort of prohibited use, possession of illicit substances, alcohol, that sort of thing. And especially around confidentiality and privacy, what are your expectations for staff around that? And then finally, on reporting any incidents. So this is reporting anything that they see another staff member doing, or that they see residents engaging in. And this is especially in an environment where they might see an inappropriate relationship between two residents. They have an obligation to report that and have that addressed. Or if they notice an inappropriate relationship between another resident or a resident and another member of staff, they have an obligation to report that and to have that addressed appropriately. And so you want to make sure that that's crystal clear, that what circumstances are they required to tell you if they see another person violating the code of conduct. And as we continue to think about equity and advancing equity throughout recovery housing, your staff code of conduct, similar to the resident code of conduct, is a great place to spell out your expectations regarding equity. And so if you do have residents who move into your home who identify as non-binary, or different circumstances, you can make it clear in your staff code of conduct that they are expected to use the appropriate name for that person, as well as their identified pronouns. And if staff are uncomfortable with that, you can have that conversation with them at the very beginning, instead of dragging a particular person who moves into the recovery home into that situation where staff had no idea that that's what the expectation was, and now there's an individual person who is in a very uncomfortable situation because staff didn't know that that was the way they were supposed to behave. Similarly, with other issues, you can outline any anti-racist or anti-discrimination policies that you have, and what specifically staff will not be or are not expect, or what your expectations are. So what they will not be permitted to do, what's acceptable and what's unacceptable. And again, having that conversation early, sets that expectation. And so staff don't just assume that something's going to be okay because it was particularly spelled out for them at the very beginning, and they're not shocked when a particular resident moves in or when something happens. All right, and so I know I rushed through those last few slides, but this is my final section here to answer any questions that you might have on the material that we have. So if you have any questions, be sure to type them into the question box. All right, I'm not seeing any final questions, and I know we've only got like a minute left. Um, and so, as with each of these sessions in our institute, we encourage you to take what you've learned and complete a homework assignment. And so we ask, so after this one, this is a great time for you to create your resident agreement and also to create your policy and paid work agreements. If that is something that you would like to do at your organization, feel free to submit those to us. We will happily review them and give you any feedback that we have, and then you can keep that in case you are applying for certification. We will review them as if you were using them to apply for certification. So take advantage of that. Send us those documents. Happy to review them. And also in the handout section, there's the Recovery Housing Development Guidebook, as well as our slides if you need those as you are developing any of these policies. All right. I'm still not seeing any questions, so I'm going to go ahead and say have a good afternoon. We hope to see you on at all of our future trainings for the Recovery Housing Institute. Keep an eye out for that survey that's going to be coming to your email probably a little later this afternoon. Enjoyed spending time with you today. Thank you and have a wonderful day.